Welcome back to Boom and Bust. I'm Tony Clement. I'm here with Ashley Baker. She is with the Committee for Justice in Washington, D.C., talking about big tech, antitrust, and all things related to those topics. Ashley, there seems to be a lot of legislative action that is starting to bubble up. I noticed that Senator Amy Klobuchar has a bill. Maybe describe that a little bit for our viewers and what the debate is about there.
Sure. So Senator Klobuchar introduced a bill about a week ago, earlier this month in February, it's a very broad bill and it addresses a lot of things. It's called the Competition and Antitrust Law Reform Act of 2021, but really what it does is completely rewrite the last 45 years of antitrust law and tells companies basically not to get too big. It has a lot of provisions that affect the mergers and acquisitions process and sort of redefines a lot of the legal terms that we use in antitrust litigation.
Is that a popular bill, or does it have any bipartisan support, or is it cleaved on ideological lines?
It's too early to say, really. But there have been a lot of moving pieces in this antitrust debate in the United States. There was a House investigation last year when the House of Representatives made some recommendations, 455, I think, pages of them. It was quite an expansive work. None of the Republicans signed on to that majority report. I don't know if we will see any Republican support for this bill or not. So far, no Republican co-sponsors, but we'll see how things play out.
Let me broaden it out just for a second. It just seems to me that, maybe the public is of two minds. On the one hand, they like having access to Facebook or Twitter or Amazon or Google. On the other hand, they do worry about privacy issues, and they do worry about, hidden or not so hidden market dominance. Is there a balance to be struck on this? What's your take on it?
I think there's always a balance to be struck, and I wouldn't dismiss their concerns as necessarily being illegitimate in terms of platform bias or privacy or these other issues. But I think what's important is what we use our antitrust laws for. And we can't, if we start using it to pursue all these other non-competition concerns, then suddenly we have, others on the left who are using antitrust laws to go after their projects as well. So it can work both ways. Laws can be weaponized for a lot of different purposes, and I think it's important for the rule of law that we constrain that.
Let's take it on the issue of competition, because you raise that as the framework for antitrust and so on. Like in the case of Parlor, for instance, that was an alternative platform for Twitter. Parlor then was denied access to the servers that would be able to, so that people could actually use Parlor. I'm not trying to get into the politics of it, but it looks to me as an observer that there's one less platform to take on Twitter as a micro messaging platform, or is that too simplistic?
I can certainly see how it looks like that. What I would point out in that dispute and what the judge essentially said at the end of the day in her response and her order is it was more of a contract dispute. It was about one party violating the terms of service. So that wasn't really an antitrust or a competition problem either. And there was no collusion that was found. So that might have been a different type of dispute than antitrust as well.
So let me ask you this then: is there a better principled approach to this debate? Because it is a public debate, obviously. How do we define a principled approach to this?
So I think the principled approach is, there are a lot of proposals that would really change the way the law operates. I think that, I think antitrust laws are they work on their own as is. That doesn't mean that more cases shouldn't necessarily be pursued. Perhaps we should give agencies more funding to pursue cases, the FTC and the DOJ. But I think when it comes to the core law itself, in terms of how it operates, such as one big provision in Amy Klobuchar's bill, for example, is it would place the burden of proof in litigation on the defendant and not the government. Mm-hmm. And I think that's really huge, and that's something that really goes against our, American system of justice and just basic system of fairness. So I think there are ways to tackle these problems that don't involve changing the law itself.
We're having this discussion with Ashley Baker of the Committee for Justice, and we will continue this discussion after the break. Please stay with us.